Friends, if you are watching this video first time, then please subscribe to this YouTube channel, press the bell icon notification button and like this video so that we can update you from time to time. Friends, we are discussing a case, the order passed by this Honorable Supreme Court of India in a criminal appeal 2291 of 2011. It's an unreportable order. So, in which there was a case there between the appellants and the respondents, and the respondent number 2, who was the complainant, he did not appear before the court either in person or through an advocate. So, the factum of the case was as the appellant here in this case was made as an accused by the respondent number 2 on the charges of the defamation, that is the 499 of the 500 of the Indian Penal Code, and he's challenged that order before the magistrate court. Means the magistrate court has first issued a summons and then he moved an application for recalling of that order. His application was allowed by the magistrate court, but the original complainant has filed a revision petition that orders of the recalling was quashed. Ultimately, he again has to face the summons, and that order was again challenged. That revision court order was challenged before this Honorable High Court of the Bombay at the Nagpur branch, but the Honorable High Court has dismissed on the grounds of delayness, and then ultimately he filed, and the appellant has filed an application. Means this by the way of the special leave petition before this Honorable Supreme Court of India, and this order has recently come. That's a reportable order, and that is on 3rd of August 2023. Let's see what's happened there in the case and how the court has interpreted it. Honorable Court has interpreted the provisions of law, and let's see. We are also going to learn with this order. The respondent number 2, who was served a notice issued by this court, but he has chosen not to remain present before this court, either in person or through an advocate, and post appeal. It means the respondent number 2 was the complainant, and he has chosen not to appear before this court. When the appeal was admitted, notices was issued by this honorable court, but he has chosen not to appear, either to contest this appeal either in person or through an advocate. This is what this first paragraph is meant about. So this is an appeal of the this paragraph says about the brief factum of the cases. Factum of this case. The facts of the case was that the original accused was summoned for the offense of defamation under section 500 of the Indian Penal Code, and is directed against an order passed by this Honorable Court of Judicature of Bombay Nagpur branch and dated 3rd of February 2010 in criminal writ petition, by which the High Court rejected the writ petition filed by the appellant. It means the appellant was summoned by the magistrate court, and he has then filed a writ petition before this Honorable High Court of Bombay at the Nagpur branch. But the order came on 3rd of February 2010. His criminal writ petition was rejected, and on the grounds that the Honorable Court declined to quash the order of issue of process by the magistrate for the offense of defamation. The grounds has not mentioned, but in the summarized form, it has mentioned that Honorable High Court of Bombay at the Nagpur bench declined to provide and relief to the appellant who was made as an accused before the magistrate court. So the material which was placed before this Honorable Court was that the appellant has filed a complaint in writing addressed to the sub-divisional magistrate stating that respondent number 2 here in the original complaint has put a shop by encroaching upon some land. It means that the appellant who has previously filed a complaint against the respondent number 2 about a shop that a respondent number 2 has encroached some land. So it's something he has filed a complaint there before the SDM office. So the appellant has made further stated that such shop put up by the complaint was creating a nuisance as many antisocial elements. Road Romeos has started visiting the shop and they was creating all sort of the problems. It means when he filed a complaint, then he further made an allegations that the respondent number 2 who was having a shop, so he has that shop has been encroached and some antisocial elements was there. I used to come there and some road Romeos have started visiting the shops and it has been creating some kind of problems. So SDM upon the receipt of the complaint filed by the plaintiff issued notice to the complaint while proceedings before the SDM was pending. The complainant thought fit to lodge a private complaint in the court of the judicial magistrate for the offence of the defamation. It suggests that when the complaint against the complainant was pending by the appellant who was by the appellant, so simultaneously the respondent number 2 had filed a complaint in the court of in the court of the CJM for the offences of the defamation. So learned magistrate took us cognizance of the complaint and issue processes. It means some kind of a counterblast complaint was filed by the respondent number 2 here in the respondent number 2 who was also the complainant here. So when he filed a complaint, the CJM has issued a notices to the appellant who is also the accused in that complaint. So cognizance of the defamation was taken place by the magistrate on the basis of the averments made by the appellant and the written complaint addressed to the SDM. As the record reveals, then the appellant moved an application in the court of the judicial magistrate with the prayer that order of the issue of the process be recalled. So when he received this summons, then after receiving the summons, he filed an application, interlocutory application, with a prayer that order of the recall may be made. So learned as the magistrate recalled that order. It means they have provided the relief to the appellant at the first moment, and then the complainant, being aggravated by the order of the recall of the magistrate, challenged the same before the session court by filing a revision petition. Now another the proceeding says that when the accused, the appellant, has got a relief from the same magistrate court, then the complainant gets aggravate from that action of the magistrate. He challenged that order before this the revision court, before the session court, and the session court has quashed not what says the content says the revision petition was allowed and the order of the recalling of the issue of the process was quashed. It means first the magistrate has issued the summon, then when thereafter the accused filed an application, interlocutory application for the recalling of the same. The relief was granted to the accused appellant here before the court of the magistrate. Aggravated by their action, the complainant then filed a revision petition, which was allowed, and as a result, the recalling order of the magistrate get quashed. It means the complainant again have to face the trial after this legal proceedings, the legal battle. Again, he was when the order of the recalling was set aside, so he again has to face the trial. So now the accused aggravated from that order. He challenged this order before the Honorable Court of the Bombay, but after 8 years. 8 years after the appellant thought it's a fit case to challenge to challenge the original order for the issue of the presence before the High Court. The High Court, without entering the merits of the matter, declined to entertain such petition on the ground of delay. It means first the order of the recall was made, the appellant accused got a relief, then it was challenged before this court of the session court. The session court has quashed the order of recall. Now the appellant accused filed a writ petition after 8 years before the court of Honorable Court of the Bombay High Court at Nagpur bench, but the court declined to provide a relief because since on the grounds of delayness, since 8 years was made, so on the grounds of delayness it was challenged. Now the contentions, then again the appellant accused aggravated from that order filed a special leave petition before this Honorable Court of the Honorable Supreme Court of India. So the contentions was raised from the both sides. After hearing from both the parties, the court has held that we have gone the materials on the record. Only question that falls under consideration is whether the allegations made in the complaint addressed to SDM make out the offence under Section 500 IPC or not. The court has framed the question of law, whether this means whether the allegation made in the complaint before the SDM will attract the provisions of Section 500 of Indian Penal Code, means defamation. The court now then analyzed the Section 499, which says defamation. The Section 499 of the Indian Penal Code says about the defamation. It says, whosoever by the words spoken or intended to be read or by signs or by visual representation makes or publish such imputations concerning any people intending to harm or knowing having the reason to believe such imputation will harm the reputation of the such person, except in the cases hereinafter accepted to defame the person. It means the sections itself speaks about certain exceptions. If and on what grounds the provisions of 499 of defamation will not attract it. There are certain exceptions are made, and this exception number 1 is the exception 8 number is means the accusations preferred in the good faith to the authorized person. It is not defamations to prefer in good faith or accusations. So the good faith comes under also defined in the Section 52 of the Indian Penal Code. It means someone who is making imputations in good faith, he can claim the exception 8 of the Section 499. So now court says after reading the contents of the sections 499 exception as well as Section 52, the court has now come into the conclusion that no case is made out to put the appellant to trial for the alleged offence. So there is no such defamation as such. Now the explanation this says, in order to support their conclusion, they have analyzed the sections. Exceptions 8 to the Section 499 clearly indicates it's not a case of defamation to prefer in good faith an accusation against any person who have the lawful authority over that person with regards to the subject matter of the accusation. It means someone who is making an imputation in good faith to any lawful authority. It means the ingredients will come under the exception 8 of Section 499. So now the court has said, even after producing the allegations made in the complaint, we are satisfied that no case of defamation has been made out. Means not only the Section 8, not only the exception 8 of the Section 499, even the allegations, averments made in the complaint, the court has said that it won't work out. It won't make out the case of the defamation under Section 499 of the Indian Penal Code. So in overall the view of this matter, we are convinced that appeal deserves to be allowed and is hereby allowed, and the impeached order passed by the High Court is hereby set aside. As a consequence of the same, the original order passed by the magistrate court issuing this summons is hereby quashed and set aside. The court says, since we are set asiding the orders of this Honorable High Court, so it automatically the issue of the process the order which has issued the process will also automatically get set aside and quashed. So the criminal proceedings in the verify the criminal case number so and so pending in the judicial magistrate first class so and so district Maharashtra stands terminated. It means the court has quashed the proceedings which was pending there before the court of the judicial magistrate. So the appeals are allowed. So this judgment, this order has come on 2nd of August 2023. Hope you have liked this video. If you have liked this video, please subscribe to this YouTube channel, press the bell icon notification button, and like this video so that we can update you from time to time. Thank you.